Furman v. Georgia, the death penalty case. Case details. In the early morning of August 11, 1967, a botched home invasion by William Henry Furman at the Savannah, Georgia family residence of William Joseph Mick Jr. resulted in Furman's arrest and Mick's death. The tragedy that was to befall the Mick family began around 2 a.m. that morning, when the married 29-year-old father of 5 awoke to loud sounds coming from the kitchen. Upon investigating the source of the noise, Mick discovered the 26-year-old Furman, who then began to flee to evade capture. The details of the events that followed are not entirely certain, as there were various inconsistencies across a number of Furman's retellings. Although, according to his own later testimony to the police, as Furman fled the residence, he turned around and indiscriminately fired a single gunshot behind himself. Unfortunately, the sporadic shot proved to be fatal, as the lone bullet connected with Mick's chest, killing him instantly. Soon thereafter, Furman was apprehended by the police while still in possession of the murder weapon and was subsequently arrested for the murder of William Joseph Mick Jr. Furman's trial was held on September 20th, 1968, at the Superior Court of Chatham County, Georgia. During the trial, in an unsworn statement allowed under Georgia criminal procedure, Furman contradicted the aforementioned story to the police and stated that as he was fleeing the Mick residence, he tripped and dropped his gun. The impact of the falling gun inadvertently caused it to discharge, killing Mick, albeit accidentally. Regardless of which story is true, Furman was largely responsible for Mick's death either way, and as a result, Furman was found guilty in the murder of William Joseph Mick Jr. In accordance with Georgia's felony murder rule, William Henry Furman was sentenced to death. However, Furman stayed death's hand, as he successfully appealed his sentence. The basis of his appeal argued that capital punishment was unconstitutional, as the parameters for its imposition varied by state and thereby violated the Equal Protection Clause of the 14th Amendment. The case, now known as Furman v. Georgia, made it all the way to the United States Supreme Court. In a 5-4 decision, the Burger Court voted not to abolish the death penalty and instead opted to set a de facto moratorium on all current death penalty schemes in the United States and set forth 2 broad guidelines that each state legislature would be required to follow in order to establish their own constitutional capital sentencing schemes for the future. Unfortunately, the Supreme Court's mandates stemming from their decision in Furman v. Georgia were incapable of resolving the bevy of criticisms lobbied against capital punishment. Today, many still express ethical concerns regarding government-sanctioned execution. Chief among these concerns is whether or not the death penalty is an appropriate vehicle for expressing social retribution in a modern society. These ethical concerns are exacerbated even further when taking the alternative of life imprisonment into consideration. Has this become our perception of justice? Regrettably, it would appear so, as 31 of the 50 total states still utilize the death penalty as their most stringent punitive measure. Ethical concerns aside, many also fail to recognize the economic shortcomings and repercussions of capital punishment. A number of expenses must be accounted for when prosecuting a capital case. These fees may stem from things such as trials, penalty phases, state appeals, federal appeals, and prison time. The thorough examination of the constitutional, ethical, and financial implications of utilizing the death penalty clearly implicate capital punishment as an antiquated government institution, and though it once served to effectively regulate societal behavior, modern American communities have advanced to the point where it is no longer an ethical, useful, or effective method of maintaining law and order in the United States, and as such, should be abolished entirely.